Your Lordship had extended the time for them to go ahead and comply with your Lordship's order of 25th of August. My Lord, if I may just beseech your Lordship to have a look at page 100 of my contempt application.
What does the compliance say? Page 16, I can see hearing regarding such and such on
That they had given a
16th
hearing,
of
now
December.
they have passed an order.
Where is it? 17?
The order is not annexed, Your Lordship.
Why? Did you
Lordship.
serve?
Yes, yes, order is there. Order is there. Order is there.
You should have annexed it.
Your Lordship, I think the order was served on the same day this was being made, so it not come.
Give a copy.
I don't have that immediately, but
I have a copy, my Lord.
Please let me see.
Your Lordship has a look at it. My Lord, I should have filed that by way of a supplementary affidavit to show that this is an aid of the contempt. My Lord, for that, I'll have to show to your Lordship, your Lordship's order at page 100 of the contempt application. Wanted
Yes.
them to consider a particular representation which restricted my scope of consideration apropos the insurance claim from X number of villages to 55 villages. So that was what the order really was. Now, in consideration on 23rd December, they passed the order saying these 55 villages will not be able to consider because you had raised the claim earlier in respect of 100 and odd villages. Therefore, these 55 villages are not the subject matter of the insurance claim. That's not your Lordship's order, Milan. They've done this only to show that this is going to become a fresh cause of action, therefore file again.
It is.
Milan, please have a look at page 100 once.
I have seen that, but
Milan,
this
specific direction was
appears to be at least 4 pages order. Now, what is there in the pages, I do not know.
correct. So I'll just show one line, my lord, from that, because your lordship's order was that they will consider my
No,
representation
but then
at
I
pages
don't think I'll
570.
entertain. Please come. An affidavit of compliance has been filed in court. Star. A copy of the order passed by the insurance company on 23rd December 2025 has been handed over by the learned advocate representing the petitioner. Stop paragraph. The petitioner is aggrieved and dissatisfied with the manner in which the contender acted for complying the direction passed by the court, comma. I am afraid that the legality and validity of the order passed by the authority cannot be gone into in the contempt application. Stop. The same gives rise to a fresh cause of action. Stop. It will be open for the petitioner to challenge the said order before the competent forum in accordance with law. The contempt application stands disposed of.
Okay.
Who is your other side?
On behalf of the state, my lord.
Yes.
My lord, the issue, Malota, I have been deprived from getting the 2 increment on acquiring Malot PST. This is the short issue.
Did
Malota,
they reject your claim?
yes.
Where is the rejection?
Yes. Malot, rejection is page 33.
Yes.
Have taken grounds of Control of Expenditure Act and copy of approval. Neither of this copy of approval is very much there. I'm a approved teacher. I'm working since 1996. This year I am going to retire. And Control of Expenditure Act, there is plethora of decision of this court that Control of Expenditure has no manner of application in my case. Malota, may I place the facts? Malota,
Did you obtain any prior permission from the school or anything?
yes.
Where is that?
School has given me, Malota, no objection. Kindly come to page 22.
Yes.
Page 22 is the school has allowed me to pursue my PhD degree, and Malota I completed February 2015 I completed. Then I have made the prayer for Malota giving me the 2 increment. Malota, I am a honors graduate teacher of also Malot master's degree holder. I am getting the higher scale of pay. And Malota, may I cite the judgment, Malota, on this issue?
No, page 22, the school permitted you, right?
Yes.
Thereafter, you obtained the degree.
Yes, Malot,
Where is it?
that is, Malot, kindly come to page 26.
26 PhD.
Yes, as it is a date of publication of the result.
Yes, 2015.
I got the Malot, the result was out in 27 February 2015. And the convocation, Malot.
From 2008 till 2015, you took time?
Yes.
Kindly come to page
1 minute,
58.
I'll hear you.
And
Yes, 26.
page 26 is the Malot date of publication of result, and certificate convocation on the basis of convocation page 28. Though that convocation is no more material, Malot date of publication of the result. It is December 2015. Now, Malot, I make the prayer for granting me the 2 increment on the basis of my PhD. That was ultimately, Malot, forwarded by the school authority, repeated occasion. Contemporaneously, I have made the prayer. But ultimately, it was decided in 2021 by the DI by sending this email that this.
All right. Yes, now show me what you want to show.
Malot, kindly consider. First, Malot, kindly consider the government had issued a Geo fixing a cut-off date, saying who are entitled for getting this to increment prior to Malot the promulgation of control of expenditure. Malot, may I read this? Malot, the second paragraph, very second paragraph. Kindly consider the relevant portion. Malot, in view of this provision and in order to accord equal opportunity to all such teachers, headmasters in the academic interest without any privilege and prejudice to any one of them, government in the school education department has decided that the teachers acquiring postgraduate degree after having had the basic qualification of honors degree in the relevant subject and subsequently improving their qualification by acquisition of PhD degree in relevant subjects, or those who were appointed with such higher degree in the above noted subject in their possession after having acquired honors degree in the regular course and then PG degree in the relevant subject shall get 2 additional increments from the date of convocation on which such degree is or was awarded. The benefit in terms of 12.5 of Geo such and such that open 1998 is extended up to 18 August 2005 as cut-off date, that is till before the publication of the Control of Expenditure Act 2005. All such pending cases can be disposed of accordingly. After this cut-off date, all the cases cannot be Malot considered for getting their Malot PhD degree. This particular Malot order, as well as the applicability of the Control of Expenditure, has come into consideration before this honorable court. Malot, I am placing that there.
এখানে রাখো না,
Malota, this is Malota, the very first paragraph, the facts has been stated. Malota, because it is completely applicable in my case. Malota, the petitioner was appointed as an assistant teacher in language group in Khagra Gurudas Tarasundari institution. His appointment was approved as an assistant teacher in the state school with effect from 10 September 1991. At the time of appointment, his educational qualification was BA Honors BT. I am also Malot BA Honors. The said educational qualification of the petitioner was recorded in the approval letter. Subsequently, he enhanced his qualification by acquiring master degree in English. Higher scale of pay admissible to the assistant teacher having master degree was also granted to him after he acquired master degree qualification in the relevant subject. The petitioner further enhanced his educational qualification by obtaining doctoral degree in English from Rabindra Bharati University in 2009. The doctoral degree was conferred upon him in convocation held on 8th of May 2009. After obtaining the doctoral degree in January, he claimed 2 additional increments as per RUPA 1998. The petitioner's prayer for grant of 2 additional increment having been rejected by the District Inspector of School AC Murshidabad on 20th of February 2012. The petitioner has come before this court with this writ petition praying for quashing of the impugned order passed by the said District Inspector of School. Follow the observation of the Honorable Court. Let me now consider as to how far the concerned District Inspector of School was justified in passing the impugned order in the facts and circumstances of the instant case. On perusal of the impugned order, this court finds that the petitioner prayer for grant of 2 additional increment was rejected by the District Inspector of School by holding inter alia that he is not entitled to 2 additional increment in terms of geo number such and such, the geo that I have referred. Let me first of all consider as to what extent West Bengal Control by Expenditure 2005 or those 2 geo dated 27 February 2009 and 15 February 2012 stand in the way of grant of incremental benefit to the petitioner in the facts and circumstances of the instant case. Government order dated 27th of February 2009 does not impose any ban on grant of such incremental benefit to the petitioner who achieved doctoral degree. Of course, the government order dated 5th of January 2012 imposes ban on grant of such incremental to those teachers who acquire doctoral degrees after the
You go to the particular paragraph. Do not read out the whole judgment.
My lord, I am pleased. My lord, paragraph 9, kindly consider. The Control of Expenditure Act has been specifically dealt with by the court. Paragraph 9. My lord, may I read?
Yes, what else?
Yes, my lord, here the court has held that there is no provision in the control of which will bar and there will be no classification in between the same class.
Yes.
And my lord, that particular geo has been set aside by the court. And thereafter, this judgment was followed repeatedly. My lord, I am placing. Kindly consider here the
Yes.
same issue. Here is also, my lord, the quoting the same geo and applicability of Control of Expenditure Act has been, my lord, referred and the prayer was rejected. The court referred the judgment that I have cited and my lord has directed to pay interest as well as cost.
Yes.
Yes, my lord, considering this as it has been settled by this honorable court, my lord, this order is not sustainable. My lord, I am only praying late because I am going to retire. My lord, let the authority be directed to confer that benefit to.
All right. Yes.
And even even the Control and Expenditure Act doesn't have any application in this matter.
But doesn't have.
As my learned friend contained, my submission before your lordship, his rights come from Rule 12.5 of ROPA 1998.
1998.
Therefore, the date of the decree is very important when he acquired the decree. Doctoral degree acquired by the petitioner on 9 December 2015. Page 28. And in view of ROPA 2009, there is no provision for such increments. And
2009.
9, which is with effect from given effect from 1st January 2006. Therefore, no way he is entitled. And my learned friend has shown.
Rejection mentions about the
Yes,
code of
might have,
expenditure.
might have.
No
That's why.
question of might have. You have to restrict your submission to the grounds of rejection. You cannot add up new grounds now.
No, my lord, I am on the basis of an order passed by this honorable court, on the basis of an order passed by this honorable court, wherein my learned friend has contested on behalf of the state. In that, it's a division bench order, my lord. May I?
Page 33 is the rejection.
Page 33 is rejection.
All right. By the way, where is the approval of your appointment?
Yes. I'm showing.
Only 2 grounds have been taken.
Kindly
Approval of
consider
appointment
that
not given.
approval is at page 20. 20. DI had approved.
Nineteen 1997.
My lord,
Your name is
my lord, that is serial 4.
Ashit Sen.
9th of
Yes.
November 1996.
Hmm.
With effect from 9th of November 1996.
October 96.
Yes. Sorry, my lord, October 19.
Yes.
And thereafter, my lord, page 21. This is the, my lord, I was allowed the higher scale of pay since my appointment because I am a master degree.
Postgraduate scale of
Yes.
pay you are given. All right. Right. So 2 grounds of rejection. One is the approval which the petitioner has annexed, and second is the application of the Control of Expenditure Act. It doesn't say about any ROPA, nothing of the sort. How can you raise
That
this issue?
since it's only once a mail, my lord, 2 objection has been quoted, my lord. But I don't find any order passed by the.
Objection. This is the reason
This
for
is
which.
the reason.
Then
But
In the
DI,
case of-
DI ought to have quoted the relevant provision of ROPA 2009.
he has not done.
He has not done.
You
Apparently.
cannot rely on
But
the
but
case
my
law.
lord, but the law, my lord, kindly once consider this judgment, man.
No, the law is very clear. You have to specify the grounds, which you have not.
cannot improve in
But kindly once for my sake,
The
once for my sake, the
petitioner,
division
no
bench
sir,
judgment, my lord.
the petitioner is aggrieved by the objection raised by the District Inspector of Schools, Secondary Education, Kolkata on 26th August 2021, rejecting the petitioner's prayer for, not rejecting, disallowing not disallowing, objecting to the petitioner's prayer for approval of 2 additional increments for acquiring PhD degree in Bengali. Stop. The first ground of objection is that copy of the approval of appointment letter issued in his favor and second is the Control of Expenditure Act, 2005. The teacher may not be accorded PhD allowances within bracket 2 increments. Stop. The petitioner has annexed the copy of the approval of his appointment issued by the District Inspector of Schools, Secondary Education, Kolkata on 8th September 1997. Stop. The petitioner's appointment stood approved with effect from 9th October 1996. Stop. He was appointed with BA degree within bracket honors in Bengali, and he was teaching the subject Bengali. Stop. The petitioner thereafter enhanced his qualification and attained postgraduate degree, and later on he obtained the PhD degree. Stop. Next. Though the petitioner was uh, accorded higher scale of pay on account of acquiring postgraduate degree, comma, but the two additional increments upon acquiring PhD degree has been objected to. Stop. Paragraph. Learned advocate representing the petitioner refers to the government order dated 5th January 2012 issued by the Joint Secretary, School Education Department, Secondary Branch, wherein a particular cutoff date was published for providing the two additional increments. Step. The issue as to whether a cutoff date can be fixed for providing additional increment to PhD degree holders came up for consideration before this court in the matter of Chaudhuri Moniruzzaman spelling versus State of West Bengal and others, reported in 2012 5 CHN 598. Wherein the court was pleased to hold that the government order dated 5th January 2012 imposing ban on grant of incremental benefits to teachers acquiring PhD degree after 18th August 2005. That is the date before publication of the Control of Expenditure Act, 2005 cannot be retained on record. Stop. The court was pleased to quash the government order dated 5th January 2012. The court was pleased to direct the authority to grant two additional increments with effect from the date when such doctoral degree was awarded to him in the convocation. Stop. While deciding the aforesaid issue, the court observed that the authority cannot create subclassification amongst teachers who acquired PhD degree prior to the cutoff date and the teachers who acquired the degree after the cutoff date. Stop. The same is not only arbitrary and irrational, but also does not have any nexus with the object to be achieved. Stop. The petitioner also relies on the order dated 9th July 2013 passed by the court in WP number 22506 within bracket W of 2012. Shankunath Pramanik versus State of West Bengal and others, wherein the court was pleased to follow the law laid down in the matter of Chaudhuri Moniruzzaman within bracket Supra. Stop. The court was further pleased to direct grant of interest on the arrears due to the said petitioner and also imposed cost upon the authorities. Stop. Prayer has been made by the petitioner to direct the authority to make the necessary calculation and disburse the amount on account of 2 additional increments at an early date, as the petitioner is due to retire from service.
This year, 2026.
When?
My lord, December 2026.
So you have one more year. In December 2026. Stop. The aforesaid submission and prayer of the petitioner has been opposed by the learned advocate representing the state respondents. Stop. The learned advocate for the state, however, contends that apart from the Control of Expenditure Act 2005, provisions of ROPA 1998 and 2009 ought to have been taken into consideration by the authority for deciding the prayer of the petitioner for grant of additional increments. Stop. The aforesaid submission of the state respondents cannot be accepted by the court. Stop. It is settled law that the authority cannot raise new grounds objecting to the prayer of the petitioner. Stop. The authorities ought to restrict their submission to the grounds which are already impugned in the writ petition. Stop. The respondents have not filed any affidavit in the matter.
Yes,
Stop.
it's a motion stage, my lord, today, first time.
Right. The matter is pending consideration before the court since July 2022. Stop. Next. In view of the above, as it appears that the law has already been settled in this regard, accordingly, similar direction is being passed herein. Stop. The objection raised by the District Inspector of Schools objecting to the grant of 2 additional increments to the petitioner stands set aside. Stop. The District Inspector of Schools, Secondary Education, Kolkata is directed to take steps to accord 2 additional increments to the petitioner on account of acquiring his PhD degree on and from
So February 2015, the date of publication. Page 26.
convocation date
Convocation is my lord,
9 December.
on and from the date of convocation of the PhD degree on the petitioner, that is 9th December 2015. Stop. Necessary calculation shall be made by the authority at the earliest and the additional increment shall be disbursed positively within a period of 16 weeks from the date of communication of this order.
I'm getting this.
This
But,
service
since-
is taken on record.
but since my lord has been pleased to dispose of this matter and in the motion stage, but kindly once, my lord, for my sake, kindly consider this order.
No, sorry, sir.
But kindly one paragraph, only
Uh,
one paragraph of this, it's a division bench judgment, my lord.
No, nothing doing. Next.
Kindly record my submission, my lord, that I have, my lord, I beseech your lordship, my lord.
No, but then you're recording your submission.
I didn't disturb your
Which
lordship.
is not a question of disturbing, since it is not one of the grounds you are saying, ROPA and everything.
but not quoting, but
used.
not quoting the other aspect of the law.
Yes.
The petitioner doesn't have any right to get the increment. It's a settled law even in this judgment. That's why, my lord, I beseech your lordship to once.
Not quoting means what? Why will the petitioner quote? It is for you to raise objection.
No, my lord, in this order, it has been clarified. Although the act on the basis of which his prayer has been rejected is may not be sustainable, but there are other reasons why the prayer of the petitioner should be rejected.
The authority has not taken those grounds.
Then, my lord, kindly direct the authority to consider afresh, so that all the law and all the settled law can be considered. Only for quoting, not quoting the
you-
relevant provision, although that
Right,
has been
right,
settled by the
right,
division
right.
bench of this court.
Yes. But then
Kindly
will
see
you
once
give-
kindly see
give-
one. Let us ekbar judge sahab ke diye.
देखिए,
Division में जानना kindly
learned
this page,
advocate for the
last
state
paragraph.
respondents relies on the order passed by the Honorable Division Bench
Division bench এর order
on 24th of April. What is the date of the order?
yes
5th of April.
no 2019
2019? 2019. In MAT 961 of 2017, এটা copy করে নেবেন তো? State of West Bengal and others versus Chandra Bhushan Dwivedi and another. Which portion?
this page last portion onwards. Body order দেখিছেন
যেটা রিলাই করে পেয়েছি আর সেটা
দেখাও
আমি আপনাকে দেখি
আর পড়তে দেখতে হবে পড়তে
তুমি এটা ইনপুট করবে কি করে
এটা দর্শক বলছেন একটু রাস্তা তো দিয়েছে এইটা এই দুটো মামলা রিজেক্ট করেছে এটার অ্যাপ্লিকেশন নেই আর এটা ঠিক আছে
But then in this judgment, where is the date when the teacher obtained the degree and everything? Nothing is there. It is only ROPA 1998.
yes since the provision as laid down by the ROPA 1998 has already been repealed by 2009
Right.
on and from 1st January 2006 and since his date of convocation is much
Later on.
later therefore he is not at all entitled to on this ground.
But then he took admission in 2008 only, when the 1998 ROPA was there.
But ultimately, when he obtained the degree,
Maybe
date of convocation,
the date of convocation was not there in 2009 Act. It was there in the 1998 Act. He, when he took admission, on that day it was applicable.
But
Then
but the relevant date is the date of convocation.
here, nothing is mentioned, isn't it?
Well, kindly record that one. I've relied on this judgment,
Acha. Hmm.
or the DI may be directed to.
So and so.
This was a for a detail also to.
But your lordship may give some observations, my lord, and direct the GI to, my lord,
And
to
subsequent
relook the matter.
substance in the appeal.
Another similar order passed by the same division bench,
Wherein the Honorable Division Bench held that as the appellant sought for the additional increments relying on ROPA 1998, which ceased to exist when ROPA 2009 came into operation. Accordingly, the additional increments cannot be paid to the petitioner. Stop paragraph. In Chandra Bhushan Dwivedi, within brackets Supra, the date of the application for the date of seeking prior permission for pursuing the PhD degree is not mentioned. Stop. In the instant case, the petitioner obtained prior permission for pursuing PhD degree when the 1998 ROPA was in force. Stop. The petitioner may have obtained the degree later on, but the benefit ought to be allowed to the petitioner, relying on the law which was prevailing on the day the petitioner started his doctoral course. এটা যেখানে রেসপন্ডেন্টের সাবমিশনটা বলা হচ্ছে সেইখানটাতে দিয়ে দেবেন।
হ্যাঁ দেখি পড়েছিল আবার since no affidavit has been
I have opposed all your submissions. So, since no affidavit.
Rule 12.5 has been considered by your lordship, my lord, and here, this last part, 3 paragraphs of Chandrabhushan case, where it is held, that Rule 12.5 of ROPA 98 entitles the holder of a doctorate degree to ask for the benefit of 2 additional increments from the date of convocation. When the convocation was held, 1990 ROPA has ceased to exist. Without a corresponding provision in the new ROPA, a division bench of this court by a judgment as so. In Gautam Ghosh observed that since the rule had ceased to exist on the day of the decree was awarded, the petitioner must be held to be ineligible to the benefit claimed by him under ROPA 98. Your lordship has
But
considered
the
this.
day I have recorded that the law prevailing on the day of starting the course will be
That should
applicable.
be the relevant date.
Yes. Number
The
2,
date of
please.
convocation.
Now call number 2, please.
Lordship. I'm sorry, my lord.
Lord, I am appearing in this matter on behalf of the petitioner led by Mr. Devasis Basu. I am paying for only 7 days time. It is changed my
and for the state
The matter was mentioned for upgradation
without notice, my lord. No notice.
without notice, and assuming the matter has been upgraded, now you seek adjournment. I am not going to grant adjournment. What is the matter about? Please place.
It is a
Prayed
matter
for
of
higher scale of pay.
higher scale of
Yes. Where is your prayer?
The commission has not been made a party, though he was appointed to commission. Page 9, 8, starting from 8.
page.
Please come. The petitioner claims higher scale of pay on account of enhancing his educational qualification. Stuff. The prayer of the legal representation made on behalf of the petitioner is pending consideration before the respondent authorities. Stuff. Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Barakpur, to consider and dispose of the petitioner's prayer seeking higher scale of pay in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties for production of documents in support of their respective stand. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the parties. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the respondent authority. Disposed. What is your name? What is your name?
অরুণ বন্দ্যোপাধ্যায়।
ওনার নামটা লিখে দেবেন।
I don't know.
Within 8 weeks.
12.
Similar, I am for the petition.
Yes.
You know, this is relates to transfer of a my lord assistant teacher. My lord, the petitioner applied through my lord Utsosi portal. My lord, it has been backed by the DI to the school. My lord, showing Geo 9 of 2020. My lord, thereafter, my lord, the school, my lord, page 27 kindly comes to page 27, the last paragraph. School again, my lord, forwarded the same, clarifying the DI's rejection. That it has been stated by the school that hence it has been clarified that the aforesaid office memo number such and such is not applicable in transfer case of the petitioner of the school, as the substitute teacher in the same subject is available in the school under the aforesaid terms and conditions. The transfer application of the Krishna Prasad Chakraborty of the school is further forward from the end of the school authority for favorable consideration. Now, this was done by the school again, my lord. Thereafter, my lord, the application has been forwarded by the school to the my lord DI. My lord, it is pending before the office of the DI since then, my lord.
The petitioner's application seeking transfer is alleged to be pending consideration before the District Inspector of Schools, Secondary Education, Purbo Medinipur.
At Tom.
Yes, without entering into the merit of the same. DI এর কাছে pending আছে, DI এর কাছে pending আছে, transfer application. Disposed.
I'm for secondary board will also. Yeah. Without any notice, my lord, matter has been uploaded. Even
And then when the matter is taken up, nobody is there. Are you there?
My lord, I have been, my lord, I'm appealing for the school, no copy has been served upon us also, my lord.
No copy has been served.
Although there was, এটা তোমার 11
no, 4 নম্বর item.
সীমা মুর্মু,
হ্যাঁ,
Yes.
ডিটেকশন ছিল ওটা। নোটিস করেনি কিছু করেনি না।
since my lord, we are following the cost title, my lord, it came.
নোটিশটা কোথায় আছে? আপগ্রেডেশন নোটিশ দিয়েছে?
আমি একটা অন্য
নোটিশ দিয়েছে না? ঠিক আছে, আপনি স্লিপটা এতে ট্যাগ করে দেবেন। The matter has been mentioned for upgradation citing urgency. Stop. At the time of call, none represents the petitioner. Stop. Learned advocate representing the board and the school.
My lord, since my lord, no copy has, I cannot file my wakalat now, my lord.
All right, you are for the school.
Yes, my lord.
Submits that the matter has been upgraded without providing any notice to, without serving any notice to them. Stop. Learned advocate for the school submits that the copy of the writ petition has not been served upon the school. Stop. As the petitioner remains unrepresented, the writ petition stands dismissed for default. Next.
Item number 12.
I've heard the petition and led by Mr. Sudeep Goswami.
I'm for secondary board will also.
It's the transfer application pending before School Service Commission. Transfer application made on 7 July.
Page 21.
School Service Commission, it is pending.
Page 21, my lord.
আচ্ছা, কমিশনারের কাছে পেন্ডিং আছে ট্রান্সফার অ্যাপ্লিকেশন।
Round of, my lord,
And divorce.
round of divorce.
Special ground, that is.
এটা একটু নিন। না,
Disposed. Next.
Item number 6.
Item 6, I am.
Okay.
I'm for the School Service Commission.
But only one request, your lordship, will the prayer that has been advanced by the petitioner in this petition, but I don't know whether how far it is feasible to.
Don't press.
I am duty bound when I have taken the brief. No objection, my lord. I-
It show cause as to why he will not be dared to offer appointment letters since the petition is qualified. I also filled up the online application of 2016. It goes.
That this is the result which was of date 2011,
Yes.
valid up to 2018. Normally it is permanent. Now the issue is, my lord, I did not get any my lord, call letter.
In the 2016 process. 2016 has been set as
This is
nullified.
my lord, upper primary.
All right,
upper
upper primary.
Yes.
Huh?
My lord, I made a representation at page starting from page 17. But actually, I am really in a dilemma, my lord, how to place the petition. What is there in the petition and my lord, how I have to place, my lord, I'm really in the dilemma.
Place Krishna.
Yes, don't press it. It's as simple.
And not
as
one
it
matter, my
is.
lord. It has 3 matters today, where he will have the same delay.
No. I have
Once.
no. I have taken
Same.
no objection in this matter, my lord. The petitioner has come.
Doesn't matter. But then 2016 recruitment process.
This is upper primary.
Upper primary. What is to be done now? All vacancies have been filled up or something. of
Yes,
that sort.
it is that matter.
But,
And he has not been called for interview even.
no, I have not been, and that is my
That means
case.
you are unsuccessful. It goes to show.
That is my case.
Please come. The petitioner alleges that
That is
he participated in the 2016 recruitment process for appointment of assistant teacher in upper primary school.
Oh,
He claims that as he was successful in
he's
TET
absolutely-
2011, he ought to have been issued appointment letter. Stop. Fact remains that the petitioner was not called for interview. Stop. The interview panel which was published expired in the meantime. Stop.
Not the interview panel expired. The main panel has expired.
Acha, the main
The
panel.
interviews were held in 2021.
Acha, the panel which was published by the commission expired in the meantime. Stop. The fact that the petitioner was not called for interview suggests that the petitioner was an unsuccessful candidate in the recruitment process. Stop. Next. In view of the above, there is no scope to direct the authority to issue appointment letter in his favor. The writ petition fails and is hereby dismissed. And dismissed.
Grateful.
I appear for the petitioner in this matter. House rent allowance is an issue, my lord, was considered by your lordship's court. My lord, whether the husband is working in a private organization or not. There was
Where is your husband working?
Tata. Therefore, he is in Jamshedpur. I am staying in Calcutta.
All right. Who's for the state?
Lordship, I am appearing for the state respondent. Matter has come in the least suddenly, Lordship, without notice.
Page 91 is the judgment of the Honorable High Court.
Been served, Lordship.
Why don't you serve notice?
I'm not ready.
Instant leave, we need to upgrade it automatically.
I'm not ready with the instruction, Lordship. Kindly give me at least 2.
অনিমেষ বাবু বলছি অটোমেটিক্যালি আপগ্রেড হয়ে যাচ্ছে
fact, I was the advocate on record at that point of time. My client made taken no objection.
And but then you mentioned prior that
Objection just after publishing the monthlies mistakenly. That is why I am here. I am tendering apology for wrong mention.
2023, Lordship.
so it is not that it has come automatic.
No,
It has
no,
been
no.
mentioned.
He has not done anything.
I am
Taking
not
the
done
change
so-
from the client, my lord, he has not done anything.
And that is why my client
He
took
was
the
a very sincere lawyer, my lord. He has applied, my lord. He has been a prayer.
Anyway, yes.
All right, it is
Page
covered by the
91.
judgment of this court, my lord, where the court had said, my lord, this circular.
May I
will
take
not
your
be
lordship kindly? Kindly don't take me Amit.
All right. Yes.
Yes.
My lord, the issue was, my lord, whether the house rent allowance should be, my lord, deducted or not. That issue
Hmm.
has been considered by Honorable Justice
Hmm.
Mantha, my lord. That page
Hmm.
91 is the judgment,
Hmm.
where his lordship was pleased to hold that no, that particular circular does not apply. Particularly, that does not apply to the university and the colleges. Secondly, it is a circular matter which is not to be applied to the school education department. And his lordship relied on the Mousumi Biswas's judgment earlier, and my lord, where the original those circulars were not applied. And finally, the honorable court has held that do not apply those, give the all arrears, those have been deducted on account of the house rent allowance, that is from January 2018 as against the petitioner, and the current salary with a house rent allowance should be paid to the petitioner. My entire house rent allowance has been withheld, given 0
Withheld from when?
from January 2018. And judgment has come out in 2022, but I have filed the writ petition in 2020.
Yes, but then did you approach the authority
Yes,
for
the
release?
authority applications are there, representations are there, my lord. My lord, my school also, my lord, has forwarded the representation. Those are the page 990.
And previously you got it.
Previously I was getting.
Acha, the house rent allowance of the petitioner has been withheld from January 2018, allegedly on the ground that her husband receives house rent allowance from his employer. Stop. The husband of the petitioner is working with a private organization and does not receive any house rent allowance from the
No,
state.
my husband is working.
State.
Not from the state. From my employer I am getting, but I am staying in Jamshedpur.
ঠিক আছে?
Husband is separately getting.
HRF from the state. Stop. The issue as to whether the spouse of the employees who receive house rent allowance from their private employer would be entitled to receive house rent allowance from the state has been conclusively decided by a coordinate bench of this court in the matter of Mousumi Biswas.
This judgment has been relied on
Another versus State of West Bengal and others on 16th March 2021 in WPA 1389 of 2018. এটা একটা reporting আছে একটু দেখে নেবেন তো reported in blank. Stop. The aforesaid the ratio laid down in the matter of Mousumi Biswas within bracket Supra has been consistently followed by the courts. Stop. One such order is annexed to the writ petition dated 27th June 2022 in WPA 15667 of 2021 within bracket Shumi Chaudhary and others versus State of West Bengal and others. ঠিক আছে? Stop. Paragraph. Yes, your submission.
Lordship, I have not received the instruction till.
Learned advocate for the state respondents is not ready with any instruction. Stop. Paragraph. As it appears that the issue is already settled by the court, accordingly, similar order passed in the matter of Shumi Chaudhary within bracket Supra is being passed herein. Stop. The respondent authorities are directed to release the house rent allowance benefit to the petitioner together with all arrears at the earliest, but positively within a period of 16 weeks from the date of communication of this order.
Without applying the impugn memo, that was the observation of the without applying the
Court's order is there, what they will apply?
explicit, they will be saying that court has not, this court has not said. She knows the view, otherwise.
The impugn. Is there any rejection in your case? There is no rejection.
No, that particular stop my payment. My payment has been stopped.
Right, but then no, there is no
Formal order is there. But that particular circular will not apply to me, so otherwise they will not give it. Excluding the
any
impugn
memo restricting a grant of house rent allowance to the teachers whose spouse receive house rent allowance from the employer
private employer.
of a private organization will not be made applicable in the instant case. This post service taken on record. That could make it.
My lord, I'm for the petitioner, but I'm being led by Mr. Nikhil Gupta. He's appearing virtually, man.
My lord, in this item number 8 and 9, my lord, it relates to 2016 SLST matter, my lord. And your
2006.
lord, my lord, my lord, my lord,
All right, then it has become infractuous.
my lord, my lord.
The matter relates to the recruitment process of SLST 2016 stuff. The entire selection process.
No, this is not one of those matters.
He says so.
No, this is an upper primary 2016 matter, not, yes.
Yes, Mr. Nikhil Gupta.
My lord, this is upper primary, my lord. 2016.
All right, then what do you want? Appointment letter?
My lord, I am a qualified candidate, my lord, but no appointment letter has been
ঠিক
issued.
আছে আচ্ছা তাহলে এটা ওই এর আগে একটা বললাম না আবার
My lord, it is same as item number 6, my lord, where
Yes, right.
Mr. Anjan
Six.
Bhattacharya was appearing, my lord.
Item 6. All right, 9 also.
8 and 9, my lord.
My lord, the affidavit of service be kept on.
Yes, please.
Extremely grateful, my lord.
Same, 8-9 same. Affidavit of services.
Dismissed.
Grateful, your lordship.
Deeply obliged.
মানে পাসওয়ার্ড দিয়েছে সময় দিল না কিছুতেই
তোমাকে তুই বলেছিস মা হাসপাতালে না সেটা তো বলিস
বলিসনি
আমি বেরিয়ে যাবো
Lordship, Robiul Islam is appearing in this matter on behalf of the petitioner, Lordship. The thing happened, actually, we overlooked the previous order, Lordship, that says to serve upon the school authority. So kindly grant us some time, Lordship, to serve and come back.
It is nearly 2 years. Who are you representing?
I'm for secondary board.
Mr. Shamimul Bari appear for the state.
But my lord, notice not served, my lord.
Lordship, we overlooked it. Kindly, Lordship, grant us some time to serve and come back.
What is the issue over here?
Well, here the petitioner was absent for more than 5 years, near 6 years, due to the reason is because his wife was not well. And thereafter his wife expired, and thereafter he wants to, I am not sure whether expired or not, but he wants to join back. But this but he was not allowed to join. That is the issue of it. Because 5 years, expiry of 5 years, that deemed resignation come. But well, that is what I remember. I don't have the brief because, your lordship, at late night I have seen the matter has come up without notice, my lord. I could not trace out the brief.
Accommodation has been sought for by the learned advocate representing the petitioner. Stuff. It appears that direction was passed by the court on 1st April 2024 for service of notice upon the school. Stuff. The same has not been done. Stuff. Let further notice be issued to the school authority. Stuff. Release the matter on 29th of January 2026. Stop. Learned advocate appearing for the respondents shall come ready with all necessary instruction on the adjournment.
Lordship, much obliged, Lordship.
Give your name only. Only your name.
Okay.
This is a gratuity interest, my lord.
Interest on gratuity. When was it disbursed in your favor?
Superannuation on
I'm
30th
the state
June
pilot.
2019. Pension payment order 9th March 2022. Payment was made April 22. Gratuity amount 3 lakhs.
Interest on gratuity, usual order. Next. Disposed.
Item number 12, I have on behalf of the petitioner, my lord. I want a accommodation because my lord, notice not been served, my lord. Comment to the government.
2023 writ petition notice has not been served.
No, my lord. Upgradation notice not been served.
Why? Why did you mention for upgradation if
My lord,
without any notice?
My lord, kindly one day accommodation.
Disposed of.
Area salary had been paid, but interest not been paid. My during the lifetime of the writ petitioner, area salary had been paid, but
When did the petitioner retire from service?
my lord,
2012.
my lord. All pensionary benefit has been
Released in 2017,
yes, my lord.
right? And you filed the writ petition in 2023.
My lord.
Why? Why?
Actually, my senior
Who is your senior?
Ashwini Kumar Bera, my lord.
Where is he?
My lord, code number 551.
Call him immediately.
My lord.
Yes, next.
My lord, I am appearing for the. My lord, I am appearing for the school. No notice was served upon us prior to upgrading.
It is intimated, my lord.
How?
Yesterday night, I have to take instruction of the school.
But the writ petition of 23, you didn't take instruction in the meantime.
Coming up after a long interval.
What? What is the matter?
Only, my lord, the scale of pay given from the date of approval. Is the PA getting in school, my lord? And all the similarly placed other teachers are given from the date of appointment.
All right.
And there is another order from of the division bench, my lord, from the date of fitment.
Date of fitment.
She was engaged on a sanctioned vacant post on the post of another teacher who retired 1 year after of her.
Where is the request before the authority?
Pardon?
Where is the request before the authority?
There is several requests.
Show me one.
Mr. Badi is leading me, my lord.
Show me one.
There is several representations, my lord. And it comes
Page 90, there is a
61.
1 minute. Page 90, I can see a hearing was conducted. Where is the reasoned order? Where is the reasoned order?
Page 74, my lord. 80. Some amount was credited to his account from the date of his approval. Her approval. And
Page 90. Come to the writ petition, page 90. You filed a writ petition earlier. And pursuant to the order passed, a hearing was called on 5th of April 2024. 23. Where is the outcome of this hearing? Who's for the state?
My lord, I am for the state, my lord. This part, my lord, I have to, my lord, check my that.
This is the only part.
Only part.
And
Others earlier that's contempt.
Earlier gone.
That has been.
I can see page 90, 23.
Only 90, my
A
lord.
hearing was conducted.
And there was another representation, my lord. Page 91 onward, my written submission, my lord. Thereafter, no order has been passed.
Please come. The petitioner seeks higher scale of pay on and from the date of his appointment. Not his, but her. Appointment.
Fitment.
Yes.
And kindly
One thing, my lord.
It appears that the issue was taken up for consideration by the District Inspector of Schools, Secondary Education, Kolkata. And a hearing in terms of the order passed by the court in WPA 93 of 2021 was scheduled on 5th April 2023. Stop. The fate of the hearing has not been made known to the petitioner. Stop. Without entering into the merit of the claim of the petitioner, as it appears that the issue was already taken up for consideration by the District Inspector of Schools, accordingly, the authority ought to have passed a final order in the matter. Stop. Paragraph. Nearly 3 years have elapsed from the date of the previous order passed by the court on 22nd February 2023. Stop. Next. In view of the above, where is 22nd February 23's order?
Page 84. ये तो DIP hearing हो.
Acha. In view of the order, in view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Kolkata, to take steps strictly in accordance with the direction passed by the court on 22nd February 2023 in WPO number 93 of 2021. Final order shall be passed by the authority positively within a period of 8 weeks from the date of communication of this order.
Last order on 24th December 2019. ওটা তো আগের আরেকটা মামলা.
That has been complied. 2019 order has been complied.
That has been complied.
Disposed.
I am grateful, ma'am.
Deputy.
14, I am for the
Service আগের মামলা service.
14.
Anybody who is not present, Shubroto Babu, anybody who is not present, name will not be recorded. Yes, please.
14, I am for the
I'm for the state response.
You also will find page 30, page 27, petitioner initially was an assistant teacher. From assistant teacher, he joined as assistant headmaster. Page 27. Since the school was a higher secondary school, page 28, as per this government order, at the bottom, assistant headmaster, serial number Roman 2. Assistant headmaster, assistant headmistress, right hand side, 2 additional increment in the revised pay of Rupa 98. This is the fixation of assistant headmaster in higher secondary school. Well, also will find page 30. DI has approved my pay scale. Page 30. Well, the 30 fixation, middle portion. Less 1 increment as assistant teacher, which I was enjoying. Thereafter, 2 additional increment was added. You will also page 30.
30, 2 additional increment allowed.
Previously, less 1
increment.
Less 1 increment 250. Then 2 additional increment. This was done by the DI. Well, the next page, page 31. After ROPA 2009, DI has fixed my pay scale. On the basis of the pay fixation, I was enjoying till my retirement. My last pay was, you also will find my page 48, 92,000, page 48. This is the pension application was submitted to the DI. I retired on 20th February 2021 and last fixation 1st July 2020, 92,000. This has been reduced, my lord, on the basis of objection raised by the, you also will find my PPO. I now I receiving pension, page 57. That is also 89,300. Last pay, you will also will find, my lord, just after 4 line, pension payment order. My lord, only I am paying, my lord, he made a representation for the fixation of pension. My lord, page 59. My lord, regarding fixation, my lord, I am not paying any mandatory order. Page 59, your lordship, my lord, can you direct the Commissioner of School Education, because the objection comes from DI. My lord, that should be considered, my lord, and to take a decision, because
When did you make the representation?
make the representation, that is
You-
after retirement, page
23.
2023, page 61.
But then page 65, I can see you approached this court earlier.
Page cases, that is, my lord, regarding overdrawn, only, my lord, challan, by challan, my lord, I refund the amount. I moved a petition, and, my lord, only this honorable court directed to refund in view of the refusal. But regarding refixation, he made a representation.
Page.
Page, my lord, 60.
Please come. What is the submission?
Yes, my lord.
What? Yes,
Let,
my lord.
my lord, this representation is required to be considered.
Also, the petitioner is a retired school teacher. Stop. He received. Now, he retired from service on 28th February 2021. And as per the pay statement, his last pay drawn was 92,000 per month. Stop. At the time of issuance of PPO, the last pay drawn was shown as 89,300. Stop. Certain sum was deducted from the PPO of the petitioner on account of overdrawn payment. Stop. The petitioner approached the court seeking refund of the deducted amount by filing writ petition being WP 4027 of 2023, which stood disposed of in favor of the petitioner with the order dated 5th July 2023. Stop. The petitioner has made representation before the authority seeking refixation of his pay scale. Stop. It has been submitted that the scale of the petitioner ought not to have been reduced after his superannuation. Stop. Paragraph.
Since the representation adjusts to the DPPG and DI, so kindly, my lord,
I'll give you leave.
to make a comprehensive representation to the
আচ্ছা। ঠিক আছে। From the documents annexed to the writ petition, it appears that the same has not been served upon the Commissioner of School Education. Stop. As the pension sanctioning authority of the petitioner was the District Inspector of Schools, and the amount and the last pay drawn appears to have been reduced upon the instruction of the District Inspector of Schools. Accordingly, the court thinks it fit to dispose of the instant writ petition with the observation that it will be open for the petitioner to make comprehensive representation before the Commissioner of School Education, annexing all documents in support of his stand. Stop. In the event such a representation is made, the same shall be considered by the Commissioner of School Education strictly in accordance with law after giving reasonable opportunity of hearing to the petitioner and the representative of the District Inspector of Schools, and thereafter pass a final order in the matter. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
In the event, my lord, the commissioner comes to in my favor.
If the prayer of the petitioner is accepted by the Commissioner of School Education, then necessary consequential steps shall be taken without any further delay. Dispose service on record.
Grateful.
My lord, I'm praying for one indulgence lordship with lordship full name and lordship. Item number 4. I was stuck in lordship. Court room number 11 lordship. It was most likely dismissed for
The court is in the midst of the list. Please do not disturb.
lordship.
Advocate for the petitioner, my lord, led by Mr. Shubhi Shanadar, senior advocate. For the petitioner, my lord, he is a student, and
where is the notice upon the other side?
Notice has not been served.
Notice has not been
Yesterday,
No,
first
your
evening,
notice not
received a
served.
notice. In fact, Lord will kindly see.
Let
May I
me hear
place
the
the case?
petitioner.
May I place my case, my lord? The petitioner student, my lord, he is agreed by the marks obtained by him in the CBSE board examinations of class 12. That was held in 2021 during the pandemic period, my lord. So the board examinations were in fact cancelled, and a certain modalities were prescribed by the board regarding computation of marks. That is at page 26. This is the notification issued by the board of 17th of June 2021.
Yes.
My lord, may straight away come to clause 4, procedure for assessment of students at page 28.
Yes.
In class 12 examination, bifurcation of marks in theory and practical or internal assessment in various subjects is as follows. My lord, in short, each subject is 100 marks, practical 80, 20, 70, 30, whatever is the subject. My lord, then comes to clause 6. This is main 6A. Due to cancellation of the board examinations, the assessment of theory portion of such and such marks will be done by the school based on the following. Class 12, marks based on unit test or midterm or pre-board examination, 40% is a weightage. Class 11, marks based on theory component of final examination, 30% weightage. And class 10, marks based on average theory component of best 3 performing subjects out of main 5 subjects, 30% weightage. Then, my lord, clause B, the marks of practical will be on actual basis as uploaded by the school on the CBSE portal. So practical examinations were already complete, held individually by the schools. So whatever marks were awarded by the schools, that were to be finally incorporated in the final result. Now, my lord, the dispute arose regarding theory. My lord, if I go from class 11 to 12, sorry, 10 to 12, class 10, it says marks based on average theory component of best of 3. 5 main subjects, we will take 3 best of those and we will compute the average. My lord, will come to my mark sheet, class 10 mark sheet of my class 10 at page 43. My lord, class 10, my lord, total is 100 marks in each subject, except computer applications where the total marks is 200. Now, my lord, will find from the statement of marks, there is no division of the theory and practical marks. Total marks, suppose man in English language, total marks at the top says max marks 100, marks obtained is 75, 98. So percentage is given 87 in English.
Are you there in page 43?
43, my lord. Statement of marks.
Yes, statement of marks.
My lord, we find in each subject, total marks is 100.
Yes.
And the marks obtained,
Right.
English language 75, literature 98. But the division is not given, theory and practical. My lord, theory was 80, practical is 20.
Even in
Even if
English
we
language,
assume-
there is practical.
My lord, in all subjects there is practical.
All right.
But even if we assume that 20 marks in practical, so we keep deducting all the 20 marks from each of these marks. Then my lord, we'll find the theory marks because we need only the theory marks for our computation in class 12 board examinations. So when I suppose in English language 75, if you deduct 20, 55. So this time, my lord, I have prepared a chart.
No, but then in 98, literature in English 98, how can you deduct 20 if the full marks is 100?
20, I'm only saying in 80. Out of 80, if I deduct 20, 20 is practical. Now this is
Right.
100.
This is
So-
100.
Yes.
So you say in language you got 75.
Yes.
It has to be taken that it is in
Both.
on
This is both theory and practical. Total is
both.
100.
All
So
right.
if we divide 20 and 80 and we take off 20 out of 75 is out of 55 means out of 80 I get 55. And here 98 means we are assuming that 20 marks I have got in practical. My lord, worst case, I have got not 20, 18. So my theory will increase automatically. So my case gets better. All the more.
No, what is your case? I do not know as
My
of
lord,
now.
coming to that. My lord, my numbers have been drastically reduced. My lord, there is no scope of any assumption over here. Only except this one. My lord, this is also board. So board better knows what marks I have obtained in my theory and practical marks. Now it's my assumption if I take 20 marks deduct. So even in literature in English, 98 comes to 78. That is out of 80 marks. Theory. Now only concerned with theory, my lord, because practical they are not doing anything. Only theory. Now what my marks will come to, that I have prepared a chart going by their own policy, how much I ought to have obtained in class 10 theory. That is at page. Page 9, my lord. No, 9, page 8. No, sorry, page 8, my lord. Paragraph 12. So, my lord, by doing that calculation, my best of 3 average comes to 23.5. My lord, there cannot be any dispute with regard to my theory marks. It is with the in the hands of the board. They are the best person to tell us what is. Next, come on, this is class 10. This way, my lord, we are taking best of 3 subjects and we are doing the average as required by their own notification. And that calculation comes to 23.5. That calculation I have given at paragraph 8. Paragraph 8 I have given the
What are you driving at?
My lord, my point is everything is based on theory.
All right.
Only weightage 40%, 30% class 11, class 12, whatever marks is given, they have to give the weightage. So there is no assumption.
Yes.
Now, my lord, whatever the mark sheet that I have received, that marks has been drastically reduced. Well, suppose in a particular subject I was supposed to get 85 on the basis of this calculation, it's 65. Mala kindly sees the mark sheet issued by the board. At page
47.
47. English code. Theory is only 60.
Page 43 is your marks.
Of class 10, my lord.
And this is
47 is the 12. Senior School Certificate Examination
All right,
2020.
12, 21, this is 19.
My lord, I have prepared a chart of what is the difference in the marks. That is at page 15, paragraph 27.
All right.
In mathematics, my lord, difference in marks 26. Physics 23, chemistry 16, computer sciences 15, physical education 19. How come this much difference is unbelievable? Everything is based on computation of marks. Now the result is that my percentage comes to 68%, whereas I ought to have got more than 80%. Now, why I am suffering, my lord? Right now, my lord, I have completed my BTech course from Vellore Institute of Technology. Now, I cannot get admission, rather job offers in prestigious companies because every company is asking for 80% minimum. I have got only 68%, at least 70% they require. Because of 68%, these marks, I cannot apply for any job. This is my difficulty.
This came to your mind after
No, my
your
lord.
claim for appointment of job gets rejected.
No.
This is a 2021
21,
examination.
2021, my lord, I immediately got admitted to Vellore. I have explained, my lord, why the delay. Vellore Institute got admission, and immediate upon admission, my lord, there were 5 semesters back to back. I could not, my lord, take up my mind and get into this court cases. Only when in August 2023 there was a gap for internship purpose. Only that time, my lord, I took. My lord, I made a representation before the principal as per their policy.
After
That was
2
also
years, Lordship.
that was also kept pending. No, within time. That
2
was
years, Lordship.
that was
Are you
within
there
time.
for the board?
I am appearing for the school. She is submitting that they have made representation before the principal. Lordship, they have applied in prescribed format for the dispute on 9th August 2021. And the representation was made after 2 years, Lordship. That is on 6th September
Prescribed format is what is to be
2023.
done. Prescribed format was done in time. They are waiting for when I will make the representation.
And they have filed this writ petition in the
That is
December
in the-
2023.
May I say, during COVID, the board could not hold the examination in usual manner. Now, a policy was, my lord, adopted, and modalities were prescribed how to, my lord, evaluate, tabulate the marks. Now, my lord, my learned friend was showing the first circular, that is 26. Thereafter, a subsequent circular was issued on 8 August 2048.
Page 48.
There, my lord, this was 8 August 2021. And this was the year when the student sat in the exam. Now, the procedure was types of dispute covered. What are the disputes? What are the types? All these things were prescribed. Now, thereafter, kindly come to next page, modalities to address the dispute, and modalities to address dispute number 3. Different disputes were there. Different. Now, under the my lord, policy, my lord, a committee had been constituted in each school. 5 members, 4 members from the subjects teacher and 1 principal. And principal was now they were to, my lord, look into the dispute. What are the dispute? Now, if there are certain dispute which were required to be sent to the board for adjudication as per this policy. Now, this policy was, my lord, approved by the Honorable Supreme Court also. As per that, my lord, this policy, because that time we could not hold the exam, there was a confusion. And now, as per that, my lord, this was said. Now, to 21, this was said. Board did not receive any specific request. But because there was a portal, SOS Shiksha portal or something, it was to be, my lord, they were required to, my lord, upload. And board, whatever disputes received by the board has looked into it and resolved the issues. There is no reason. Now, kindly see, as my learned friend pointed out, the result was published in the year 2021. Kindly see at page 47. And the writ petition was filed in the year 2024. Now, what is the grievance? Now, kindly, Your Lordship kindly comes to their letter. The reason being, at page 53, this is the only letter they have. Before that, my lord, this was in 23.
No, my lord.
Now,
23.
kindly comes, Your Lordship kindly take, they have discussed, kindly, if Your Lordship kindly comes to page 56. This is the reason why they are asking for, they have filed the writ petition and now they are seeking orders. Now, my lord, it happened 21 and
24.
At page 56, last para. It is noteworthy that currently I am pursuing BTech in Computer Science in Vellore Institute of Technology. The classes are Vellore, commenced from 13 September 21. And prior thereto, I had to appear in several entrance examinations that were being conducted by the different universities and colleges, my undergraduate course. After joining Vellore Institute of Technology, I had to appear in 5 semester examinations without any break in between, except occasional breaks of about 2 weeks only. After back-to-back 5 semesters, finally there has been break of 5 months from 1st August 23, so as to allow us to undergo internship in different companies. Such being the situation in the interregnum period, it was not possible for me to take any further steps with regard to the aforesaid application dated 9th August 21. This is a then be it mentioned that all major reputed companies have a minimum requirement of 70% marks in class 12 to be eligible for internship in such companies. Having obtained 68% in class 12, for no fault of mine, I am being deprived of these opportunities. Under the circumstances, I request you to kindly take up the matter with the controller of the also. Now, my lord, we did not receive any, my lord, complaint at the relevant point of time. We could not. Had we received any complaint, my client has instructed me, only there were mass, my lord, representation from 101 students from the school in 2021. Now that was looked into, and whatever complaints were required to be looked into, we have done it. Now result was
What is page 52?
52.
Applied for the dispute.
Yes, she had applied for
Clearing the dispute.
raising the dispute. No date.
No date.
No date.
Was it at all uploaded in the portal or anything of that sort?
According
There
to
is
this was not uploaded. No. This is a specific instruction I have received. Instruction, my lord, written instruction. They have said, my lord, I'll just only one instruction. Here in the instruct case, the school had raised mass representation of 100 students, 101 students without any proper verification record by not specifying any error in computation as per guidelines of policy. It was simply stated that the students and parents are agitated and not satisfied with the result. This was the only, there was only one mass representation. In fact, my lord, if your lordship kindly takes that 8th of August 21 circular, there was a, my lord, procedure prescribed.
My lord, page 52 is a representation that I was supposed to make in terms of their own policy. My lord, their policy, my lord, kindly comes to page 48. Clause 1, my lord, types of disputes or cases covered. What are type 1 and type 2 disputes? Disputes regarding computation of results. Next paragraph, below, the result committee has prepared the result and uploaded on the website of CBSE for its computation. In case candidates feel that they are not satisfied with their marks awarded, they can make representation to the principal of the school for verification and reply by the school to the candidate concerned. My lord, next page, my lord, page 50. That is clause 6, schedule of activities, type 1.
This is important.
Start date 9th of August, end date 11th of August. My lord, page 52, that's not written, my lord. My specific averment at page 11, paragraph 17. Petitioner made an application before respondent number 6, that is the principal, far back on 9th of August 2021 in terms of the circular dated 8th of August. Praying for revision, however, till date, petitioner has not received any reply, nor has his result been updated till date. 52, my lord, as per their own policy, within time of 9th of August, I made to the principal. I waited, no reply received. It was only then this page 53 representation was made. They are only relying on the representation, not on this, as per their own policy, what we have made. My lord, delay, my lord, already explained, my lord, I'm a student, my lord.
Very well,
It's
please
not
come.
possible for me to go up behind this in court cases.
The petitioner appeared in the Senior School Certificate Examination, 2021, conducted by the Central Board of Secondary Education. Stop. He is aggrieved by the marks awarded to him. Stop. Paragraph. As the subject examination fell during the COVID period, the Central Board of Secondary Education published a circular on 8th August 2021 as per the direction given by the Honorable Supreme Court, prescribing the policy for tabulation of marks, and the manner in which the disputes of the students are to be resolved. Stop. The petitioner contends that that objection was raised within the due date before the school authority in terms of the aforesaid circular in September 2021, but the petitioner has not been intimated the fate of the said objection. Stop. A written representation was made to the school on 6 September 2023, but there has been no response to the same till date. Stop. The petitioner has disclosed in the representation filed before the school that though the result of the board examination was declared একটা জায়গাতে বললাম না যে September 21 he made representation. First representation was made on August 9th August 2021. পরেরটা হচ্ছে 6th September 2023. ঠিক আছে? তারপর কি বলছি? Was declared in July 2021, and he made the objection before the school in August 2021 in terms of the circular dated 8th August 2021. But as he was pursuing BTech course at Vellore Institute of Technology, and he had to appear in several entrance examinations conducted by different universities and or colleges for admission in the undergraduate course. Accordingly, he could not ventilate his grievance before the either before the board or before this court prior to 2023, when he got a break of about 2 weeks. Stop. The petitioner submits that he got very high marks in the class 10 board examination, but his marks in the class 12 board examination got substantially reduced. Stop. Because of illegal reduction of marks in the class 12 level, the petitioner is losing his opportunity to get appointment in good companies. Stop. The prayer has been made to revise the marks of the petitioner awarded in the class 12 board examination and to issue fresh mark sheet. Mentioning the revised marks. Stop. The submission and prayer of the petitioner is opposed by the learned advocate representing the board and the school. Stop. It has been submitted that the examination was conducted way back in 2021, but the petitioner has approached the court in the year 2024. Stop. Learned advocate for the board refers to the modalities set out in the circular dated 8th August 2021 for redressal of the disputes raised by the candidates. Stop. It appears that the board set up a, within quotes, school request submission for resolution system, where the disputes were to be uploaded. Stop. A committee was constituted for resolution of the disputes. Stop. The circular prescribed specific timelines within which the disputes were to be resolved. Stop. It appears therefrom that the entire process of resolution of the dispute ended in August 2021. Stop. Paragraph. The petitioner, though claims that an application was made through the school within the time schedule disclosed by the board, but the learned advocate representing the board submits upon specific instruction that the mass request made by the principal of the school was duly considered and disposed of. Stop. There was no request for or on behalf of the present petitioner. Right?
We did not receive a specific complaint. This was not received. So
the specific complaint allegedly made by the petitioner annexed to the writ petition at page 52 was not received by the board.
And no date. That kind.
Stop.
Does not bear.
The subject objection at page 52 is an undated one, and there is no proof that the said representation was either submitted before the school or the board. Stop. Next. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials before this court, it appears that, admittedly, the result of the subject examination stood declared in July 2021. Stop. 2021, stop now. During the COVID period, stop. The board claims to have acted in terms of the circular which was issued on 8th August 2021 in compliance of the directions passed by the Honorable Supreme Court. Stop. The dispute redressal committee set up by the board has been dissolved in terms, dissolved on the date as prescribed in the subject circular. Stop. Though the petitioner claims that objection was filed within the prescribed date, but it appears that the petitioner was not vigilant enough to proceed with his objection. Stop. He proceeded with his studies in the graduation level. Stop. Only after expiry of more than 2.5 years after publication of the board result, the petitioner filed the instant writ petition on 4th January 2024, claiming relief against the board by praying for issuance of fresh mark sheet upon revision of the marks awarded to him. Stop paragraph. The court is of the opinion that the explanation provided by the petitioner for the delay in approaching the court cannot be accepted in the facts and circumstances of the instant case. Stop. The board cannot be mechanically directed to revise the marks of the petitioner. Stop. The committee, which was set up for the particular purpose, is no longer available. Stop. The circular and the guidelines and modalities published by the board are no longer in force. Stop paragraph. Had the petitioner been genuinely aggrieved by the marks awarded to him, he ought to have rushed to either to the authority or to the court within the shortest time possible. Stop paragraph. The same has not been done. Stop. The court is not inclined to interfere in the instant writ petition. Stop. The writ petition fails and is hereby dismissed.
Right.
The entitlement is not disputed, Madam. Only.
I'm state respondent.
Petitioner? Yes.
But it's a very long pending case, and there are several writ petitions have been moved before the High Court, and there are several orders, including his transfer, suspensions, allowances, and subsequently.
What is your prayer in the instant writ petition?
He has been retired. Subsequently, he has been retired. Now I claim for any retirement benefit without any due process of law, whether I am entitled to any retirement benefit or not. There is no departmental proceedings due to unauthorized absence, due to my medical ground. And now at this stage, my lord, I claim.
When did you retire?
No.
2023.
23. All right.
That is when this petition was moved.
16th. Any, भूल है 31st July 23.
How many years did you serve?
My lord, according to he was initially appointed on compassionate ground due to die.
Group D staff.
His father as a group D staff.
When were you appointed?
2016. 2006.
When?
My lord, it is appointment letter is there.
And initially.
Yes, by the 4/5/2006. 4th
All right.
May. 4th May.
Yes.
Thereafter, he was continuing service. Subsequently, he met this accident in 2013.
All right.
And thereafter, he totally absent from his
without cause.
from the school.
Right. So from 2006 to 2013, you served.
Yes. Thereafter,
you could not join.
He made an application for transfer, general transfer, with no objection certificate from the school authorities, but that was not granted. Subsequently, he filed a writ petition before the High Court, and High Court directed to give him no objection certificate. And that no objection certificate was subsequently not given. But in the meantime, he was again moved during the suspension period to give a suspension allowances. That was also not allowed. Subsequently, order was passed by the High Court that yes, he is entitled to get a subsistence allowance, and that order was passed by the High Court, and that order was subsequently recommended by the DI of schools at page, my lord, kindly. It's
Page 43.
43, no?
81. 81.
সেটা তো পেয়ে গেছি।
No, তাই না। My lord, that is 81A, my lord, page. Yes, 81A, my lord. Page 81A. Additional District Inspector Schools. Boni Amin, Group D staff was absent from Atu to Atu. The school authority suspended with effect from 2015. Suspended in 2015 by meeting number such and such. The school authority also asked the Boni Amin for giving his reply in the suspension letter dated such and such, but the school authority did not get any reply from his end. Proposal for approval of suspension of was disapproved by the West Bengal WBSSC and 2016, which was communicated by officer number such and such, was requested to send a fresh so-called notice to Boni Amin. As per decision of the said hearing such and such, the authority issued so-called notice to Boni Amin to reply within 7 days from the date of receipt of the letter by dated the school, but the school authority did not get any reply from his end. As per produced copy of the service book attendance register, it appears Boni Amin was absent from 10/12/2013 to 4/10.
So you practically served from 4th May 2006 till October 2013.
Yes.
How are you entitled to get your terminal dues?
According to my lord, thereafter suspension order has been revoked by the High Court. That order is also there.
Page? Page 82 to
That's Sarafir order, that's a Saraf. That's a Sarafir order.
No. Order.
That's a Sarafir order.
You should have been prepared. You cannot waste such a lot of time.
Almost petition, my lord.
Almost petition.
No. Sorry, my lord.
Come ready. It cannot be done in this manner.
Yes, my lord. There is so many orders there.
Not today. Nothing doing. Call the next matter, please.
That's a Sarafir order.
Lord, I am for the petition in this matter.
Lordship, I am for the secondary board.
Lord, I have a very limited prayer before your lordship today. My lord, the petitioner belongs to the Calcutta, the two authorities. Petitioner are the assistant teachers of Calcutta Airport English High School, which is located at the land of the Calcutta Airport. My lord, this is an integrated school, primary, secondary, high secondary. It's a private school, but the management is run by the board, West Bengal Board of Secondary Education, because it is under the ad hoc committee of the board. Previously it was under the administrator appointed by the board. Now, my lord, my only grievance is that, my lord, I was appointed nearly 23 years back. My lord, I was given the pay scale in terms of ROPA. Until ROPA 98 I received. Since ROPA 2009 and 19 came up subsequently, our pay scale has been reduced, which is not permissible, even below the 98 ROPA which we used to get. Now, my lord, we made several representations before the board, my lord. Let my representation be considered at page 83. That is my humble prayer, because it is to be computed.
Last occasion, Lordship, 14th May 2024, coordinate bench was directed to serve fresh copy of the school authority, Lordship. Lordship, school is the
Ad hoc committee.
Honorable Justice.
Well, this ad hoc committee has got changed. That is under the board itself.
But school did not.
No, it is a board appointed ad hoc committee. So board before the president.
Lordship.
School, there is no managing committee.
The petitioners.
Well, I prayed also
Seek
the area
pay protection.
along with area.
A representation by the petitioners is pending consideration before the West Bengal Board of Secondary Education. Stop. Without entering into the merit of the same, the instant writ petition stands disposed of, directing the board to consider the prayer
My
of
lord,
the
I have
petitioners
a DI instruction of DI.
strictly in accordance with law at the earliest, after giving reasonable opportunity of hearing to all the necessary parties.
My lord. Thank you.
আমাকে একটা কপি আছে না?
না। দিয়েছি।
আচ্ছা, ঠিক আছে। A reasoned order shall be passed and communicated to the parties. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Instruction forwarded by the District Inspector of Schools, Primary Education, North 24 Parganas, dated 10th May 2024, is taken on record. Character line. Leave is granted to the petitioners to forward all documents in support of their claim to the aforesaid respondent at the time of communicating the order of
My lord, pay fixation along with area and interest, kindly mention that. Otherwise, they will say that
whatever is there in your
no,
representation.
your lordship has recorded pay fixation. They will say that you have not mentioned.
Pay protection,
Pay protection
not
is including
fixation.
area and interest, my lord. I have made clear.
Pay protection. If you are entitled to the protection, you'll get everything.
Yeah, very well. We have been facing this problem since 23 years. That is why I'm a bit apprehensive, my lords. Grateful to your lordship. My lord has directed for a hearing also to be called as CSS. Grateful.
I beg to appear before your lordship through your virtual mode, my lord.
Yes.
Can you
Lord,
allow
I
me?
am appearing on behalf of state in this matter.
At the very outset, my lord, I must submit before your lordship the intimation upon the concerned the advocate of the concerned respondents was given only on yesterday, my lord, evening. As my lord, I was not well to move this matter remaining physical present before your lordship. If your lordship kindly permit me to move this matter through virtual mode, my lord.
Yes, certainly.
My lord, I shall place the prayer portion before your lordship to cut short the matter. This is there is a checkered history in this matter, my lord. Your lordship kindly have a look to page, my lord, 40, the prayer portion.
Yes.
My lord, your lordship will find, my lord, Board of Secretary, President, Board of Secondary Education, Respondent number 3. I have prayed from giving any effect to or further effect to the purported order dated 10th August 2023, passed by the President Ad hoc Committee, West Bengal Board of Secondary Education, as it appears, the letter of communication dated 12th September 2023, issued by the Deputy Secretary General, West Bengal Board of Secondary Education, containing the order passed by the President Ad hoc Committee of the Board dated 10th August 2023, without annexing any copy of the same, along with the purported letter of communication dated 12 September 2023, wherein it was declared that Srimati Shukla Pandya Rajak, assistant teacher in history of Ghospur Sri Nehru School, High School, Post Office, Ghospur under Keshpur Police Station, is deemed to have been resigned with effect from 22nd December 2012 and accordingly ceased to be in employment of the said school, creating the vacancy of the post with effect from 22nd December 2012, as she remained absent for more than 5 years from the school in accordance with Rule 11, Sub-Rule 1 of the board's leave rules. But the second prayer was more particularly President West Bengal Board of Secondary Education, Respondent number 3, to supply the purported order passed on 10th August 2023 in compliance with the order passed by the Honorable High Court on 26 June 2023 in WPCRC 118 of 2023 in WPA 10425 of 2001, 20, that would be by 2021. As the impugned order passed on 26 June 2023 is not in existence now, which was clarified by the Honorable Division Bench in MAT number 2023 with CAN 01 of and CAN 2 of 2023 passed on 11th October 2023, holding paragraph 10 of the order shall not be considered to be a finding of the learned single judge with regard to the claim of the writ petitioner, either for employment or condonation of absence or any other right as directed under the paragraph 15 of the impugned order. Next, my lord, prayer was President West Bengal Board of Secondary Education, respondent number 3, district.
No, it is all right. Your prayer has been couched in such a manner that the entire writ petition is there in the prayer. Right?
Yes.
No, so you are aggrieved by the deemed resignation.
Yes.
My lord.
What is your
Last.
submission?
Last minutes.
But only later of communication was there, but no order passed by the president, my lord. That was not served with the copy of the communication letter. That was not given, my lord. While, my lord, the appeal against the order passed by the Honorable Justice, my lord, Rajasekhar Mathai, the contempt jurisdiction, my lord, that was under challenge for the Honorable Division Bench. And the Honorable Division Bench held that that was not the observation of the learned court in a contempt proceeding. That was the submission of the learned advocate on behalf of the board, my lord. That was so, my lord, the decision taken by the my lord, president, that was not served upon me first of all, my lord. Secondly, my lord, the order passed by the honorable judge is not in existence as per the order passed by the division bench. Your lordship kindly have a look to the order passed by the Honorable Justice Rajasekhar Mantha in contempt proceeding, my lord.
On 26th of June 23.
Yes, yes, 253, page 253.
Page number.
Yes.
My lord, your lordship kindly have a look to the order passed by the Honorable Justice Rajasekhar Mantha, page 253. Your lordship kindly have a look to 253. May I read that, my lord? In a contempt proceeding, page 253, your lordship kindly have a look to.
Yes.
This court finds both the president of the West Bengal Board of Secondary Education and the headmaster of the school equally irresponsible. The teacher in question was absent for more than 11 years from the school. A plain reading of Rule 11(1) of the Leave Rules of the West Bengal Board of Secondary Education would indicate that a teacher absent for a continuous period of 5 years is deemed to have resigned from the service unless the headmaster of the school recommends any special reason to the board to treat the absence of the teacher and condone the same. The headmaster and the president of the West Bengal Board of Secondary Education have been passing the buck between each other by reference to Rule 11(1) of the Leave Rules of the West Bengal Board of Secondary Education. Issue has been stuck in red tape as a consequence of the sheer carelessness of the president of the board and the headmaster of the headmaster. The students have suffered for 11 years. The school has explained the management's stand but has chosen not to make any recommendation as to whether they want the teacher to serve in the school and whether the board should condone or consider condonation of 11 years of absence. President of the board has behaved in a pathetically bureaucratic manner despite letters from the headmaster. He ought to have explained and sought specific instruction from the headmaster. M.S. Bhattacharya, learned counsel appearing for the board, submits that there ought to have been resolution from the managing committee of the board school. In the above process, the students of the school have been deprived of teacher for next page, your lordship kindly.
Paragraph number 10 of the said order, the court has already
Yes, my lord, your
decided.
lordship. Yes, paragraph 10, teacher Shukla Rapaja Rajak shall be treated as having resigned from the school from the day she absented herself from the school. The headmaster of the school as well as the president of the board.
Yes, yes, it's all right. Then what has happened?
But what is this observation of the Honorable Court, paragraph 10, teacher Shukla Rapaja Rajak shall be treated as having resigned from the school from the day she absented herself from the school. It was not the observation of the court, it was seemed to be the same. But I prefer an appeal against this order. The Honorable Division Bench will not have a look, your lordship kindly have a look to the next
6-1.
Page 260, 61 it starts from. I am reading it out, page 261.
6 and 7 of
Milord, your lordship, MIT 1755, there was a delay, that was condoned, Milord. MIT 755 of 2003 can 2. Appeal is arising out of an order dated 26 June 2023, passed in a contempt proceeding.
See, admittedly, you have absented for more than 11 years then and now, maybe how? What was the date?
No, your lordship kindly have a look.
14 years.
I
Then
am
what
coming to
is-
that. I am coming to that. First, I am placing this not 11 years, beloved. I was beloved made sufferer as I belong to beloved scheduled caste community, beloved, and later on, beloved, I was beloved became mentally beloved imbalanced and was admitted in the hospital and was under treatment from beloved January 2013 to 20th October 2020. Thereafter, I was issued fit certificate and applied for joining there. And no proceeding was initiated against me till date. And this was my submission that under what circumstances, due to the school authority, their misbehavior and conduct, failed to such imbalance, mental imbalance for which I was treated under the doctor from here to there. And ultimately, I was admitted in Bangalore.
No, all said and done, what is the relief that you are claiming now?
But I was praying for joining, resuming my duty since 2020. Honorable High Court was moved and Honorable High Court directed the petitioner to submit a representation detailed submission. I have submitted. That was not considered, which will compel me to file contempt application. And
So right now, you are aware of page 264. You prefer appeal, whatever you've got to do. Then cannot be done.
Appeal court paragraph 5, your lordship. If we treat this to be a finding of the largest single judge, then it is not permissible to make such.
No, this is not an appealable order, your lordship, because after the proceeding concluded, if a final order is taken, that is appealable. Well, this is as per rule 11 of the leave rules that a person.
Where is the final order?
This is the final order.
Page
No. Well, this is not the final order. Well, the final order is under challenge before him, my lord. That, my lord, as far as I remember, it was long back or mattered. No notice served upon me in the. However, I could grab the brief in the morning, couldn't go through it. But what I find, there was in the order passed by.
My lord, supplemented affidavit is below. I have filed below.
Serve a copy. As per I remember, my lord, I have served. But my lord, long back, I don't remember. Even my lord, if it had not been served, I'll serve it. I'll take an instruction whether served or not. I'll serve upon it.
Please come.
Yes.
My lord, one supplementary affidavit, my lord, annex.
Yes, later on, my lord, I was served with a copy of the order passed by the president of the board. Kindly, my lord, accept the supplementary affidavit containing, my lord, the order passed by the DPI, president of the board.
That was his prayer in the supplementary affidavit.
Yes.
Supplementary.
Kindly have a look to the script order. There is nothing. My application is still pending decision, my lord.
The Did you serve a copy of the supplementary upon the respondent?
Yes.
My lord, it's my fault. My lord, in the last night, my lord, I have.
So where is the final order? It is 7 and 8 pages. No, 15 and 16.
No, my lord, this is.
Your lordship kindly have a look to page, my lord. Page 14. Your lordship kindly have a look to page 40. Starts from page 40. 1-4.
Where is the final order?
This is the letter of communication. Next page, your lordship kindly have a look to page 15. Page 15 note.
Reach the petitioner, my lord. This is the note.
Handwritten note, my lord. There is no order as such.
That is why I'm submitting a lordship. I have to take instruction whether the final order has been submitted to him or her or not. Because there is a final order. This is the note.
Page 15, your lordship kindly have a page 15 in the final order.
I'll hand over the final order to Mr. Maiti within day after tomorrow.
Let the final order by the board be forthwith handed over to the learned advocate for the petitioner if not served earlier. Released next Thursday.
Next.
A matter to appear before the Lordship, my lord, your Lordship kindly
Next.
consider the prayer of the petitioner. My lord.
কত তারিখ গো?
Next Thursday, 19.
15?
I'm deeply obliged.
Thank you, I'm for the petitioner. Interest on gratuity, my lord.
Grateful, deeply obliged to your Lordship.
এক্ষুনি ফোন করবো না মনে রাখবি ফোনটা করে নিয়ে নেবো
I'm dismissing it.
বিনামিন কি হলো
My lord, the
Pradeep, some dates. Petitioner retired in the year 2015. PPO 10th May 2016. Writ petition filed in February
my lord,
2024.
my lord, received my lord 23, my lord, I have received my lord.
What you have received?
My lord, the entire my lord, money, my lord, the pensionary, my lord, the pension, area pension, gratuity, and everything, my lord, I have. My lord,
Your PPO was issued in 2016.
yes, my lord, that was my lord came pending, my lord, due to some my lord deficiency in paper. My lord, that was my lord, my lord, I have mentioned my lord there 6th November 2013, 23, my lord, I have received.
Where are documents
My
in
lord,
support of your case?
My lord, I have paragraph 4, my lord, I have.
Paragraph will not show you show that you received the money on such and such date.
Well, yes, my lord, then my lord kindly adjourn for it. I have supplementary evidence, I shall disclose everything.
Why supplementary?
My lord,
In the main writ petition, it is not there. When the order is passed for dismissal, you say you
No, no, my lord,
file supplementary.
I have mentioned my lord, when I have received my lord, that I have mentioned.
Where is the documentary evidence? Once PPO is issued, it is taken that the money is disbursed in your favor. Soon thereafter. And from 16 to 23, for want of documents, how could the PPO be issued if the
My lord,
documents were not there?
There was a dispute my lord, in between the my lord, school and my lord, board, my lord, that's why my lord,
That has hardly got anything to do after PPO is issued.
my lord, that's why my lord, I'm seeking leave, my lord, to my lord, they annex the my lord, those documents my lord, by supplementary evidence. Kindly my lord, don't my lord, dismiss my lord, kindly give liberty to my lord.
Acha, likhun to. The petitioner seeks interest on delayed payment of his terminal dues. Stop. From the PPO annexed to the writ petition, it appears that the petitioner retired from service in July 2015 and PPO was issued in his favor on 10th May 2016. Stop. The instant writ petition has been filed on 26th of February 2024. Stop. The court is minded to dismiss the writ petition on the ground of delay. Step. Learned advocate for the petitioner submits that though the PPO was issued in May 2016, but the money was actually disbursed when?
6th November 2020.
On 6th November 2023. Step. There is no supporting documents in respect of the submission made by the petitioner. Stop. The petitioner, learned advocate for the petitioner seeks leave to file supplementary affidavit. Stop. For ends of justice, let supplementary affidavit be prepared and circulated by 16th January 2026. Release the matter on 20.
I beg to appear for the statement.
My lord, I am for the petitioner, my lord. But I'll show only one page, my lord. That is page number 86, my lord. This is the, my lord, merit of my case. The year of 1987, my lord, I have joined with Bishnupur Sir Ramesh Institution as an assistant teacher. Subsequently, my lord, on May 29, 2000, I have been transferred to my lord with the and after that, my lord, working with respondent number 6, Jangra Adarsha Vidyalaya, in the designation of headmaster. Subsequently, my lord, at that point of time, my lord, I have selected for contributory provident fund crime gratuity scheme, my lord. Subsequently, my lord, in the year of 2014, a notification came. And my lord, according to the notification, I have switched over from contributory provident fund cum gratuity scheme to pension cum gratuity scheme, my lord.
My lord, the principle of the notification was that, my lord, when I will switch over, my lord, what I have received in terms of contributory provident fund cum gratuity scheme, my lord, along with interest, I have to refund back. That I have done already.
Show.
My lord, page number 68, 69, if your lordship kindly come. I have received 3,43,544. My lord, subsequently I refunded back, my lord, along with interest, that is 4,67,240.
Yes. Has PPO been issued in your favor?
My lord, issued in my favor.
Show me the PPO. Why are you? What do you want?
My lord.
My lord, give me a few minutes. I'll explain. He's too junior. Actually, his original client is
Original.
original petitioners. His petitioners.
The petitioner my lord, died in the year
Died in the
2020.
instead.
Petitioner has died.
Husband of the petitioner.
Husband of the petitioner died in the year 2020. Interested in 2014, right?
My lord, husband of the petitioner were serving with the respondent number 6. He died in the year of 2020. After 2014, my lord, he was receiving the pensionary benefit. But my only grievance is, my lord, since as I have retired in 2009, my lord, 1st of April 2009, my lord, since 1st of April 2009, since I have refunded back the amount in the year of
You ought to have got it from the date of, retirement, and not from the date of refund.
My lord.
The date of retirement. Widow is the petitioner.
Lord, since 1st of April 2009, 22nd of September 2014, my lord, I have not received. That is my grievance.
Yes, disposed.
Grateful, my lord. নাম তো দিও।
হ্যাঁ ডাকুন।
In that matter, I am for the petition.
Yes.
This is for the arrear salary with interest. So during the pendency of the writ petition, arrear salary has been paid. 9,21,000 has been paid.
When?
So I paid on 9th February 2024. So I am paying only the.
Where is the document to show it has been paid?
So, my lord, there is two file. One file is not test. There is supplementary affidavit file. I can, if you.
Where is the supplementary affidavit?
Not yet been filed, but the original copy I have not traced out. But this is the copy where the document of the payment has been annexed, my lord. 9th February 2024, during the pendency of the writ petition, the arrear salary has been paid. 9th February 2024. So I am paying only the interest.
9,21,000.
Yes, yes. Original copy, there is another file I could not test out.
And it was due from which date?
Yes.
The amount was due from which date?
From which date, my lord? It is stated in the supplementary affidavit, my lord. They were coming. Paragraph 5 of the supplementary affidavit. Since September 2007 to 8 February 2024. Paragraph 5 of the supplementary affidavit.
Please come. The instant writ petition was filed by the petitioner praying for a direction upon the respondents for releasing his arrears salary.
One thing I shall submit, my lord. A pension payment order at Treasury Officer Howrah, but the arrears salary paid, he served at Jhargram district. Arrears salary has been paid by the district inspector Jhargram. But the treasury officer Jhargram was not made a party. For that reason, I have filed a application for addition of party to add the treasury officer Jhargram as a party respondent.
আচ্ছা কি বললাম?
Should be fair, otherwise it will create difficulty.
Which remained due from September 2007. Stop. During pendency of the writ petition, comma, the arrear's salary has been released in his favor on 9th February 2024. Stop. The petitioner has filed a supplementary affidavit. No, not filed. Prepared a supplementary affidavit annexing his passbook of the bank to show that the payment was credited in the account of the petitioner on 9th February 2024. Stop. Right now, the petitioner prays for interest on account of the delayed payment of his salary. Stop. Paragraph. Anybody there for the state?
I am very sorry I could not communicate to the other side, my lord.
Just imagine, you upgraded the matter. There is a noting that you have to give notice. You did not give.
Observe that.
You are obtaining order.
So, your lordship kindly fix it any other day. In the meantime, myself. That will be better for and fair.
The court is trying to come to the aid of the litigants.
Yes, very
and
sorry.
this is how the advocates are performing.
My lord, I am very sorry.
As the original of the supplementary affidavit has not been filed before the court, comma, hearing of the writ petition stands adjourned till 14th January 2026. Stop. Let copy of the supplementary affidavit be served upon the learned advocate representing the state respondents. Stop. As per the leave sought for by the petitioner in the connecting application, Can 1 of 2020.
One.
They can even.
Can 1 on 20.
কত item? 12. Can 25. The Treasury Officer Jhargram is directed to be implemented as a party respondent in the instant writ petition. Stop. Let copy of the supplementary ki serve korte bollam. বলেছি তো? ঠিক আছে. Can is disposed. Make the correction immediately.
Okay, very sorry, my lord.
May I have your lordship kindly put it and request lordship. Item number 4 most likely have been dismissed for default lordship.
If nobody was not there, what can be done?
I about lordship. I know the code number 11 lordship.
Somebody should have been here. This is an updated matter.
I unconditionally apologize. Also. Kindly make it not.
ছিল না respondent এর জন্য somebody was there. হ্যাঁ আমার মনে হচ্ছে ছিল. Side.
Mr. Biswajit De is appearing as a state law advocate lordship. I said informing course of their lordship. You will logically make it not.
What is the matter about?
It's about unauthorized exams are being conducted lordship in the school without taking permission from the board lordship. That is why that is the subject matter of the.
So this is of the year 23.
23 lordship.
The examination is long over.
But going on private exam lordship, CA exam and all those private exams are still continuing lordship, despite lordship notification certificate lordship by the Board of Secondary Education lordship that without permission no private exams can be conducted lordship.
Check up who was there. Somebody possibly was there in the morning.
Lordship.
And you give notice. Come at 2 o'clock.
My lord, I have this indulgence, my lord. Just to make a contempt matter. The rule has already been issued regarding the demolition of a building against corporation. But that was on process. But since it was fully occupied, it could not be completed within time. Today, my lord, I have been intimated. She was a junior in the matter. The my lord I would be pleased to take up the matter at 1:15. I do not know exactly. That was the direction or this.
1:15.
Yes, today.
Matter has been fixed at 1. No.
She has been informed.
I don't know who has informed how.
320, item 320 lords.
Whatever, 320 possibly was mentioned.
My lord,
Item number 21.
So, my lord, would your
Your
lordship be
lordship.
kind enough to keep in mind, my lord, my junior will be here if.
Why will you not be there?
I'll be here.
Yes, please remain. Well, item 21, yesterday your lordship was pleased to pass an order if it will be taken. Second up. If it will be taken up by your lordship, then lordship will kindly fix a date. I had a talk with the advocate general. He said that let a date be fixed and to intimate him. They have not.
My lord,
My lord,
my,
item
excellent. My lord,
Well,
in
I
this matter, my lord, where my lord, senior my lord is mentioning before your lordship, I challenge the rule in the compassion of
They
conscience.
are
So yes, so this is why my lord, senior my lord has been engaged in this matter. But now, my lord, the situation is right now there, and thereafter the order of this honorable court very recently, I will not press this challenge to the rules. I will state on, my lord, just go on the merit on this matter. So if my lord, senior my lord, press my lord, be there, possibly subject to lordship's correction, my lord, requirement of my learned senior, my lord, the advocate general may not be required.
So before another bench, you went on to challenge.
Now,
And
this is not anybody. I tell your lordship, what is what. But after
don't tell.
After I
Don't tell.
Item 4, he is representing for board lordship.
Yes.
No lordship, but state lordship.
4, you were there when the matter was taken up.
Mrs. Bhattacharya was there.
Right. Was anybody else appearing for the respondents?
State must be appearing.
State appear করেছিল?
No, I don't know, your lordship.
You don't know.
Also, kindly make it not today. I shall notify in course of today, lordship. Kindly make it not today, lordship.
All right, I'll make it not today. File ta onion in. You check up the YouTube recording and see whether anybody was there for the state or not.
I'm also checking with GP office, lordship.
That is different. But then you check up from here also if anybody was there. Serve. Matter will remain in the list.
I'm grateful. Lordship.